The Third Circuit Court of Appeals response. See, it's addressed to the from the Court of Appeals. I got the case number from last year, 22. Let's see, judgment rendered and mailed to all parties. They say that I filed, and they received it last year, June 29th. Root of review on the docket of the Natchitoches City Court, Parish of Natchitoches City Court with Judge Owsley, Dishonorable Judge Owsley, and that's the three people. The Court of Appeals sent their response to the judge, my lawyer, and the prosecutor from Lake Charles, Louisiana. Writ granted and made peremptory. On June 27th, this court received defendant's supervisory writ application following his conviction and sentence for resisting an officer. In his writ application, defendant asserts 4 assignments of error. The trial court erred when it failed to provide the accused the assistance of counsel in his defense. The court erred when it failed to find defendant not guilty. The court violated defendant's constitutional rights at trial, and the trial erred in failing to rule on the merits of his motion for post-verdict judgment of acquittal, and his motion for new trial with supplements. Under State v. Herald, 92 issues of sufficiency of evidence are to be reviewed first before considering assignment of trial error. Based on the officer's imputed collective knowledge, the accurate description, and tip provided by the librarian and officer's observations, this court finds there was sufficient reasonable suspicion to approach, detain, and question defendants. During the valid investigatory stop, defendant continually refused to provide his name and any identifying information in violation of 14-108.
Defendant in Louisiana has the constitutional right to appointed counsel in any misdemeanor. Although sufficient evidence was introduced to support the conviction, defendant's conviction and sentence should nonetheless be vacated. The Supreme Court has held that an indigent defendant in Louisiana has the constitutional right to appointed counsel in any misdemeanor case punishable by a term of imprisonment. State v. Stevenson, 97 3122, Law. October 30th, 1998, 721 So 2D 843. In this case, defendant was subject to a term of imprisonment, and defendant maintained the position that he was indigent. The trial court indicated that it had reached out to the public defender's office, which determined defendant had sufficient resources to hire private counsel. However, no evidence attesting to defendant's financial status was placed on the record. The trial court then assumed defendant was choosing to move forward since he did not hire private counsel. However, under State v. Daigle, 07928, Law. App. 3 Sir. January 30th, 2008, 974 So. 2D 869. Before a defendant may waive his right to counsel, the trial court must determine whether the defendant's waiver is intelligently and voluntarily made. In the instant case, the trial court failed to adequately advise defendant of the dangers and disadvantages of self-representation. The record does not establish that defendant chose self-representation with eyes wide open. Id. At 876. Thus, without further evidence that defendant had sufficient funds to hire a private attorney and made the conscious decision to proceed on his own and waive his right, defendant's constitutional right to be represented by counsel was violated. The trial court should have properly determined if defendant intelligently and knowingly waived his right to counsel, and this error cannot be considered harmless. Accordingly, The trial court abused its discretion by proceeding without first finding a valid waiver of defendant's right to counsel. Therefore, defendant's conviction and sentence are vacated, and defendant is hereby granted a new trial. This matter is remanded for further proceedings consistent with this ruling. Although sufficient evidence...
And they initial their names, and so I had to do a little research to find out what these initials meant, and I wrote down these names. So that's who the judges are. Look, without knowing, I just kind of guessing there. I think there's 2 females and a male. And then this is the mail that my lawyer received, addressed to his office. From the Court of Appeals, certified, cost $4.75. And that's it.